Hi, thank you for joining our webinar. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Lynn Thompson, a Mississippi construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I would like to introduce the fabulous Lynn Thompson.
Well, good morning and good afternoon to some of you. I'm sitting near Jackson, Mississippi, and going to talk to you today about Mississippi lien law and Mississippi bond law. This is for informational purposes, and I hope you find it very useful. I've been practicing law for about 30 years. I'm also licensed in Virginia and Georgia, but today it's all about Mississippi. Okay, so here's the fine print. It's not legal advice, but you knew that. And I'm very glad that you could join us. If you have questions, you can include them in the webinar chat box, and we will get to those at the end of the webinar. Don't include any identifying information. Okay, let's get to the meat of the coconut. Lien rights and bond rights, they only work if they're exercised timely and properly. So before you start providing labor or services, you need to know where you fit in on the chain of construction and what rights you have in that position and what obligations you have to protect those rights. If you're a prime, you have a lien right. If you're a subcontractor in Mississippi, you also have a lien right. If you're a subcontractor, second tier, you have a lien right. And if you're a materialman or a supplier to a first tier subcontractor, you have a lien right, or at least you start out with a lien right. If you're below a second tier subcontractor, or if you're a materialman or supplier to a second tier sub, you do not have a lien right. Now, like I said, you start out with a lien right, but there are some things you must do to preserve it. If you are not properly licensed in Mississippi, then you have forfeited your lien right. You could be one of the, like a prime or a first tier subcontractor, but if you are performing work that exceeds the value of $50,000 and you do not have the proper certificate of responsibility issued by the Mississippi Board of Contractors, then you no longer have a lien right. You have nothing to enforce. Now, if you so you don't want to blow your lien rights by not following the law. You don't want to start out by undercutting yourself. Okay, Mississippi's lien law is premised on the notion that the owner is entitled to know who is providing work or services on their property. It's designed to give certain tiers of subcontractors and suppliers the right to file liens, but it's also designed to allow the owner to know the universe of entities who could file liens, so that the owner can keep tabs on the prime contractors doing its job of paying its subs and making sure their subs are paying their subcontractors. And I know this because I was involved in the committee that wrote this statute. We didn't have such a law until 2016, so it hadn't been around that long. So with that notion in mind, that's why our lien law provides that if the owner asks the prime contractor in writing to provide a list of all subcontractors and suppliers who are furnishing labor or materials to the project, and if the prime contractor willfully fails to provide that information within a reasonable time, then the prime has forfeited its lien rights. Now, there is the same thing is true with subcontractors. If the prime contractor, if your prime asks you in writing for a list of who your subcontractors and suppliers are, and you do not provide that information within a reasonable time, then you have forfeited your lien right. Now, there's nothing that prevents a subcontractor from voluntarily providing notice to the owner of what it's furnishing to a job. If you provide the notice, in a nice way, introduce yourself, You can talk about your skill set or who's going to be out there. If you do it in a nice way, the owner is going to know who you are, what you're doing out there, and has a better ability to ensure that all proper payment is being made to you by the prime. Now, another way we see this right to know foundation of the lien law is that if you are a subcontractor or a supplier to a subcontractor, then you have to give your own notice that you are on the project and what you're supplying. The subcontractor you're working for may or may not give notice of who its subs are, but you must make your participation in the project known to the prime contractor. Otherwise, you as a sub or a supplier to a subcontractor have forfeited your lien right. And the way we enforce this in Mississippi is if you are a subcontractor or a supplier not in privity of contract with the prime contractor, within 30 days of the first date that you provide labor or materials, you must give written notice of that delivery. And the delivery notice should include the name, address, and phone number of the person providing the labor, services, or material, who's going to be out there performing the work, the project location, where you're going to be providing the services or the materials, and a description of what you're going to be doing. And if you have a firm fixed price or know what the price is going to be, you should include the contract price in your notice to the owner. Now, another requirement to keep you from forfeiting your lien, I alluded to this earlier, both parties on each side of the contract have to be properly licensed in Mississippi. So if the prime contractor has a certificate of responsibility, but subcontracts to a subcontractor who should have a certificate of responsibility but doesn't, then that contract is going to be considered null and void, and the subcontractor doesn't have a lien right, nor will the prime. That's very easy to see which contractors have licenses by the Board of Contractors. You can go on the MSBOC website and do a search, and I encourage you to do that before you even submit a bid in Mississippi. Okay, another requirement to maintain your lien right is you have to make proper payment to lower tier contractors. If you're a prime, you have to pay your subs, and subs, you have to pay your subs. If you are not making proper payment to the lower tiers, you have forfeited your lien right. Finally, you must be in substantial compliance with whatever your contract performance obligations are. If you abandon the job, if you're significantly late, if you're not supplying enough material to the job or enough laborers, and are not in substantial compliance with your contract, then you will have forfeited your lien right. Okay, I'm always surprised at how many clients don't read their contract or that are not familiar with their contract, but reading the contract and reading the room is going to get you a long way. Your owner, your project managers, your superintendents all need to be thoroughly read in to what the contract requirements are. It's not just enough for the owner of the company to know, but anyone that's supervising and in charge of supervising, they need to know what the contract requires, what documentation needs to be kept, when do the payment applications need to be submitted, what documentation must go with them. Are you being delayed, or are you delaying someone else on the project? You need to be able to write proper notice letters to the appropriate contractor of problems that are on the projects. Something that is materially impacting your performance obligations needs to be put in writing to the appropriate person to receive notice for your other contracting party. Doesn't need to be a nasty letter, just needs to be proper and practical. If you keep it professional, hopefully you'll get a professional response in return. But you want to be out in front of any project issues that could create performance and payment disputes. If you are a subcontractor at any tier, ask for the prime's payment bond. You are entitled to a copy of that by statute in Mississippi. And if there's no payment bond, get out in front and request a copy of the legal description of the project. If there isn't one and your subcontract is substantial and you want to make sure you can preserve your lien rights, you need to start to work to get a legal description of the property, because you do not want to wait until the last minute. And by reading the room, what I mean by that is you need to understand the contracting party you're dealing with. If you see that there's a blame campaign that's getting started, maybe there's some design issue, maybe there's a subsurface issue, any number of things that come up on projects. If you sense that your contracting partner is laying in the weeds or trying to make their problem your problem, you need to be on top of that and sending out your notice letters. Okay. Consistent with that, document your events, daily reports. Make sure you keep those up to date and they're thorough and accurate. Project meeting minutes. Attend the project meetings if there are any. Ask for a copy of the prime's project meeting minutes or prepare your own, but make sure that you are steadily documenting what's transpiring on the project. Scheduling. Are things arriving on time? Are they going to be late? Are you going to be impacted by another contractor's work? Delivery dates. What's holding those up, if anything? Mark them and keep track of your compliance with those things. Like I said, give the advance notice and notice of an impact if you see one coming. The more prepared you are, the more your organized internal reporting is a standard procedure, you're going to be ahead of the curve. You're going to be able to document whatever you need to support your claim, which hopefully you won't have one, but you just don't know. Okay. Where are you and who do you know there? If you're going to file a claim of lien in Mississippi, you have to file a lien affidavit and you have to provide a legal description of the project property. You might be in a rural area. You may be in a heavy industrial area, but you're going to need to have your legal description ready. And you don't need to go looking for this or searching for it when you're down to the wire on a potential lien claim. Where's the courthouse? Sometimes these logistics can be deal breakers for filing a timely lien. Your project may be in one county, but the courthouse where you've got to file your lien is in another. So who do you know there? How are you going to get there? What's the filing fee? You may have left the project already by the time you need to file a lien. So who is going to do the work for you? You need to have contacts in the area that you can get in touch with on short notice if necessary. Okay. If there is a bond on the project, you're going to need to know what it says. Sometimes bonds have very specific notice provisions. There are statutory notice provisions, which I'll get to in just a minute. But if the bond has certain requirements, you need to make certain that you are complying with what's stated in the bond. Is your claim going to be timely? You've got to make sure that if there are certain timeliness requirements that you comply with those. And claims documentation, what do you have to document your claim? Because the first thing you're going to get after you send your notice of claim to a surety is a request for proof of claim. And if you've, from the previous slides, if you've got your documentation in a row, this is not going to be difficult. And the sooner you can provide it to the surety and they can analyze it, the faster you're going to get paid. We have had instances where our clients' claims documentation is very thorough, it was very credible, it was consistent, and sometimes the surety is going to get in touch with their principal and say, hey, you really need to look at this. The faster you can convince a surety of the solidness of your claim, of its credibility, they may work with their principal to avoid a legal claim on the bond. Now, in Mississippi, you do have a statutory right to get a copy of the bond. So as soon as you get to work on a project, you need to request it in writing so that you have it in hand. Now, if you are a first-tier subcontractor, you don't have any special notice requirements to perfect a claim on a bond. But if you are a second-tier subcontractor, or if you're a supplier, then you're going to have to give 90-day notice to the prime contractor of your bond claim. In other words, within 90 days of your not being timely paid, you need to give your notice of claim to the prime contractor. And if you don't make a timely pre-claim notice, then filing a legal action on the bond is going to be problematic. You have to comply with this pre-suit notice. So, watch the clock. And this relates to liens. If you file a progress payment lien waiver in Mississippi, if you have not received, well, you are presumed to have received payment within 60 days of the date of your lien waiver, whether you receive payment or not. You have to be very careful about that. Now, the lien, a proper waiver of lien for a progress payment should include notice of that 60-day paid presumption that we have, but if it doesn't, it's still going to apply to you. So that's a really good time. You look at watch the clock, and it's 60 days. If you haven't been paid or before your 60 days run, to preserve your claim of lien, you've either got to file a notice of intent to lien or an actual lien. Now, I like using the pre-lien notice because the owner, number one, the owner is going to pay attention to it. And you don't actually have to go in there and file a notice, a claim of lien, but the pre-lien notice, which will preserve your lien right, will usually result in your getting paid. So don't let that 60-day presumed payment period run. Be in touch with counsel in advance and be ready to file your pre-lien notice. And if you want to, within the 90 days, file the claim of lien. If the pre-lien notice does not result in payment within the 90 days of the last date that you furnished the labor or materials, you will need to actually file the lien. This is the same rule that we have that relates to both progress payments and the final payment. Is you need, within 90 days of the last date that you furnished labor or material, your lien for what occurred is going to run. So you need to calendar your 90 days of the last day that you provided labor or materials if you need to file a lien for that. And on final payment, same thing, 60 days presumed payment from the date that you filed gave your lien waiver. So say you're bumping along and it's 45 days since you submitted your final payment application with your lien waiver, you need to be preparing a notice of claim of lien so that you can get it timely filed within 60 days, either the notice of the intent to claim a lien or an actual lien. And by all means, make sure you file your actual lien within 90 days of the last day that you supplied the labor or the materials. The 60-day presumed payment is a good time. I'd set my calendar with some sort of alarm somewhere to go off at 30 days, 45 days, and be on top to either file the lien or give the pre-lien notice. Okay, so the claim of lien, you're going to have to timely record the lien. Got to be recorded within 90 days of the last date you provided labor or materials. And remember, in Mississippi, even punch list work counts. For some projects and some other states, you've got to be doing something substantial, and punch list work might not count as labor or materials furnished to the job, but in Mississippi, it does count. After you file the lien, you've got 2 days to give timely and proper notice to the owner and or the prime contractor that you have filed the lien. You must comply with this legal requirement. Then you're going to have to file a timely payment action to enforce that lien. You can timely file the lien and get it recorded, but if you don't file your lawsuit to enforce the lien, then you will have lost it. If you have an arbitration right, you still need to go ahead and file the payment action in circuit or chancery court, whichever is appropriate, and then it's going to be circuit court. Then you can preserve your arbitration right and file your arbitration demand. Now, you must file your payment action within 180 days of the date that you filed your lien. But if there's a notice of contest of that lien that's filed by the owner or another party contesting the lien, then your time to file your payment action gets shortened to 60 days. So you don't want to be looking around for someone to help you with that in the 60 days. Just know that you have a much shorter period of time. Now, a claim on a bond. You have to file your claim within 1 year of the last date that you provided services or materials to the project. Now, again, if you are a second-tier sub, you have to have given the notice to the prime contractor within 90 days of the last day that you furnished the labor or material in order to be able to file a lawsuit or a legal claim on the bond. So you need to calendar those dates and give notice to the prime. Otherwise, you will lose your claim on the bond. And in Mississippi, if there is a payment bond in place, you don't have a lien right. Our payment bonds take the place of lien rights. So if a bond is in place, and that's a good thing, you've got a well-documented claim, don't blow it by missing the filing deadline. In Mississippi, you are entitled to interest by statute. We have prompt payment statutes in Mississippi. So you need to be aware of those and include references to claims of interest in the liens that you file. And in your payment actions to enforce the liens, you need to include that. In Mississippi, attorney's fees for perfecting liens and filing suits to enforce liens, it's permitted. Courts are not required to award attorney's fees, but they certainly can. They have the discretion to do so. I don't know if y'all have any questions. I went through that kind of quickly, but if you have any questions, feel free to send them in.
Well, first of all, thank you so much, Lynn. That was a wonderful webinar. I really appreciate it. As for the questions, I don't see any questions as of right now. However, if anybody does have a question, please feel free to reach out to myself or to Lynn, and we will be sure to answer any questions.
That's great. Thank you all.
Thank you all. And that's all we have for you today. Thank you so much for everybody who attended. We hope to see you at our next webinar. Have a sunny day.